Before we get too far into discussing specific courts by name, I thought it would be a good idea for us to go ahead and begin by looking at court systems in general. So what I'm going to do is talk about three levels that you typically see, whether we're talking about the federal court system or the Texas court system, or really any state court system, typically consists of three levels. So the intent in this presentation is just to give you a better idea of the distinctions between those three levels, the functions of each one of those levels. So let's take a look at those three levels. I'll introduce you to their general names, and remember, whether we're talking about Texas state court systems or the federal court system, they're going to have specific names, and we'll get into those specific names at another time. I just want to give you an idea of what these three levels are. So as I said, we typically find in the United States three levels of courts. Let's introduce you to each one of those very briefly. The role and function of each level is going to be different, and this is something that that my students they have an idea of what a courtroom is, and they typically understand what an appeal is, but we're going to try to fine-tune that idea. So typically starting in the court systems, you're going to have at the bottom the trial courts. Going up to the next level, typically you're going to find an intermediate court of appeals or a system of intermediate appellate courts. And of course, up at the top, you'll have a Supreme Court level. Some states, just as an example, actually have two courts at that Supreme Court level. So there are some distinctions there, but generally these are the three levels that you're going to find in court systems, whether we're talking about Texas or the federal court system. So let's look at that bottom level, the trial courts. This is the one that students are typically the most familiar with. If you read a book about courtroom drama, this is probably going to be the setting of trial court. If you've seen a movie or watched a TV series about courtroom dramas, it's most likely going to take place in a trial court. There's nothing real exciting, I suppose, about the intermediate level court of appeals or the Supreme Court. A bunch of judges and some lawyers talking about a case, trying to make a decision. But this is where most students discover this is where the action is. This is where you're going to have witnesses. Now, I put here that this is the court of original jurisdiction, and you'll learn in other parts of this module and submodule, the word jurisdiction is a word that refers to power or authority. Specifically speaking, it is jurisdiction is the power that a court has to render a binding decision in a case. The power that a court has to render a binding decision of in a case. So when I refer to this as the court of original jurisdiction, this is probably where this case begins. So look at the courtroom systems and court systems as a forum that governments establish as a way to resolve conflicts between the individuals that live inside of their society. Court systems go back in time as far back as we've studied civilization, even at the tribal level and primitive levels. There's always been some sort of a court system. Good governments have always established forums for the people living within their boundaries, where they can go and resolve disputes. When you have people living together, there's going to be disputes, and good governments set these up. So at the bottom level, you have the trial courts. So let me put a few things here. The first thing is that you need to know that a trial court, you're going to have one judge and one jury. There may or may not be a jury. There's always going to be a judge. You'll learn more about the differences between a bench trial and a jury trial, so I won't go into the distinctions. You may or may not have a jury. And by the way, this jury is a petty jury, and that's spelled P-E-T-I-T. Another thing that you're going to see at the trial court level is the introduction of evidence. Evidence can take many, many forms. It could be a document. It could be testimony from an actual live witness. It could be a murder weapon. It could be something boring like a contract or a deed to purchase, a deed that represents the purchase of land. All kinds of evidence can be used and introduced here at the trial court level. One thing that I want you to be aware of is that a record is kept. We have what are referred to as trial courts of record. Records have to be kept, and the record is kept either by some sort of voice recognition technology, or perhaps a camcorder or a webcam of something like of that nature, or you may have someone that's referred to as a court reporter who's very, very good at distinguishing between who's speaking at the time. Some of these court reporters, also known as stenographers, we're talking about 225 words a minute they can record. They have their own shorthand language in essence. But it's very, very important for you to understand that a record is kept. A record is kept not only of who speaks and what they're saying, and it's very, very important that what the judge says is kept, and the record is kept, and you'll understand more about that. But also we have a record of the evidence itself. So if a document has been introduced, then we have a record of that. That is, the trial court clerk will keep that. Or if you have a photo, that is part of the evidence. That becomes part of the court record. Now, let's move up to the intermediate level, the intermediate appellate courts. This is different from a trial court. It's a court of review, and I think when you think about this, you'll understand why I emphasize this record that it has to be kept at the trial court level. And generally speaking, what an intermediate appellate court is going to do, which is a court of review, is that they're going to check to see if the judge made a mistake at the trial court level. This is why we call it a court of review. In other words, whoever lost at the trial court level and they make an appeal, really what the basis of their appeal is that, hey, we had a contest down here at the trial court level. There are rules of evidence or rules of procedure that the combatants here have to follow. This judge, though, didn't allow the trial to take place in a fair manner. The judge made a mistake in the way that she allowed this contest to take place. Violation of the rules of evidence, violation of the rules of procedure, whether we're talking about civil procedure or criminal procedure. So think on that just for a moment. An appeal is really based on a claim that the losing party at the trial court level is claiming that the trial court judge, that one judge, made a mistake, made a procedural error, and now we want the intermediate appellate courts to take a look at what this trial court judge did. Take a look at the record. Take a look at what this judge said in the trial, the objections that were made, and how the judge responded to the objections, so on and so forth. So, generally speaking, these intermediate level courts of appeal do not have trial jurisdiction. That's not what we have here at the intermediate level. We're not talking about wiping the trial court decision out and then having a new trial at this level. That's not the way that it works at all. This court is going to review what happened at the trial court level. So no new trials here, no new evidence. They're not empowered to have juries. That's not what happens here. What they're simply concerned with is looking at the record of the trial court, particularly looking at what the judge did, how the judge ruled, what decisions the judge made. At the intermediate level, we don't have one judge who's looking at the record of the trial court below them. Rather, what you're probably going to see is a panel of judges, perhaps a panel of three. Three is typically what you'll see, whether you're talking about state level or even the U.S. federal level. You're looking at typically a panel of three judges who review the record of the trial court. Now, there are three things that this intermediate level court can do. They can either affirm the decision at the lower court level, and what they're saying, if they affirm it, is we've reviewed the record and there doesn't seem to be any material mistake that the trial court judge made. So we're affirming the decision of the trial court. Or they can remand it. And a remand is sending it back down to the trial court. That's an order. A remand is an order, sending it back down to the trial court with instructions for the trial court to try this case again. So in other words, they saw a mistake that the judge made in the record, and rather than have the trial all over again at their level, they're sending it back down to the trial court judge to tell them what the error was and ordering them to retry this thing. This time around, don't make the same mistake. One other possibility, although it's a rarity, is for an intermediate level court of review to actually reverse the decision of the trial court. Now, this is not likely going to happen. It's most likely going to be an affirm. Second, perhaps a remand. Rarely is it going to be a reversal, although they do happen, so I need to mention it. A reversal is when the intermediate level court of appeals sees the decision that the trial court judge made. Let's say, for instance, the trial court judge found for the plaintiff in a civil case. Well, on review, this court says, the intermediate level court says, hey, this should have been for the defendant. This was the defendant's case. And so they actually reverse it. Most of the time, it's going to be an affirm, as I've mentioned before. The three choices, affirm, remand, reverse. Affirm is most likely going to happen because the trial court judges typically do not make mistakes, or if they do make mistakes, they're not deemed to be what's referred to as material. And what that means is that the judge may have made a mistake, but it's such a minor one, we don't think that it actually affected the final outcome. Now, the next I want to look at is the Supreme Court. So at the Supreme Court level, this is the highest level. This is the final court of review, and I want you to note that it says review, which means its function is similar to that of the intermediate level courts of appeal. So if you understand what I mean by review, then I don't have to go into that again. They're looking at primarily the trial court level. So this is one more step of review. So the intermediate level court, that's your first chance of review, and then of course this is the last chance of review. So this is the final court of review. It's similar in function to intermediate level appellate courts in their reviewing of the trial court record. Reviews the record of the trial court, and then it's going to take a look at the reasoning of the appellate court, the intermediate level appellate court review, and those same three choices are there: affirm, remand, and reverse. So I won't go into what those are, just explain that. Those are essentially your three levels. Now what we'll do in this course is we'll take a look at the specific names of the courts, whether we're talking about the Texas state court system or the federal court system.